Domestic violence charges are handled differently, at least I handle them differently, than normal criminal charges such as an assault on a stranger or a break-in and entering, something like that. They differ in several ways. Number one, there's a time frame issue because typically when a client comes to see me about a domestic violence case, there is also, in addition to the criminal charges, a related civil case going on that we refer to as a 50B action, which is a domestic violence protective order, or a 50C action, which is sort of a non-stalking order. And those civil hearings take place within just a few weeks of the event, whereas the criminal case can stretch out for months, maybe even years. And so we have to jump in quickly, complete our investigation, interview all the witnesses, prepare whatever legal arguments that there are in a much quicker fashion. And then we have to be aware that whatever happens in the civil case can be used against my client in the criminal case. And so we have to be very careful about what evidence we bring out or whether we allow whether I allow my client to testify at the civil case, knowing that the result of the civil case is an order that typically lasts 6 months to a year, mainly to say stay away from the other person. It can also award some assets or custody of children temporarily, but the criminal case that's going to come later can end up with extended jail time and long-ranging consequences that could affect what inevitably becomes a divorce or child custody proceedings, things like that. And so there's a real balancing act that goes on there in determining with each client, and it varies from client to client, which is more important, the civil case that's going to happen quickly or the criminal case. And then sometimes we can sort of work with the other person's attorney if they have one and the district attorney to try to work out sort of a universal deal that will resolve both cases in my client's best interest.